call to the faction loyal to former Senate President David Mark, Jibrin Okutepa, SAN, praised the Supreme Court's judgment for upholding their position and setting aside earlier decisions that affected Mark's recognition as party leader on the Independent National Electoral Commission INEC portal.
In other words, the basis upon which INEC acted to remove the name of Senator Mark and his escort had been removed by the Supreme Court, agreeing that the order of status quo antebellum made by the Court of Appeal was unwarranted and no basis to make it was unnecessary. But affirm that we should go to raise the question of jurisdiction before the trial court.
Also reacting, the National Publicity Secretary of the David Mark-led faction, Bolaji Abdullahi, called on INEC to reinstate David Mark's name on its portal, insisting that the Supreme Court's ruling invalidated the opposing claims.
It's a victory for multi-party democracy in Nigeria. We have repeatedly maintained that anything contrary to what the Supreme Court had ruled will have set Nigeria's democracy back by many years. So we are glad, we have remained confident in the judiciary. We have repeatedly maintained that we are confident in the judiciary, and we are very proud as Nigerian citizens today that the Supreme Court has not let the judiciary down, has not let Nigeria down, and as Nigerians we are very proud. And this means to us that democracy will survive in Nigeria. Then we can go back and begin to do the hard work of politics.
The Supreme Court of Nigeria has delivered judgment in the long-running leadership dispute within the African Democratic Congress, bringing renewed attention to internal tensions within the party. In the ruling delivered yesterday, the Apex Court addressed competing appeals over the legitimate leadership structure of the party. The dispute involved rival factions laying claim to the control and administration of the ADC's national leadership. On the other side, counsel to the faction led by Nephew Bala, identified as Robert Onogwero, welcomed aspects of the Supreme Court's decision, particularly the decision to refer part of the matter back to the Federal High Court. He maintained confidence that his client's position remains strong and expressed optimism about the outcome at the lower courts.
We are going back to the Federal High Court for the case to be heard on the merits, on the basis of the order of the Court of Appeal for accelerated hearing. Let me make the point. The order for accelerated hearing made by the Court of Appeal was not a subject matter of appeal. So nobody challenged that order. So that order is still subsisting. So there's an order for accelerated hearing. So the Federal High Court, go ahead this case and hear it expeditiously and decide it.